I guess we're hot. Thank you. Good morning, ladies and gentlemen. Welcome back to Bexar County Court of Law number 6 in the Bexar County Veterans Treatment Court. I'm Judge Wayne Christian. We have 2 pleas and a motion to revoke probation scheduled today via Zoom. Today being Thursday, October 6th, year of our Lord 2022. It's approximately 10:35 a.m. Representing the state in all matters will be Assistant Criminal District Attorney John Stan Heinrich. Representing the Bexar County CSCD will be Ms. Susan Gross, who I will swear at this time. Ms. Gross, I don't see you. Are you there somewhere?
Yes, Judge.
Susan on?
I'm here.
There she is. Please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. And as you can tell, Susan is dying, and it's very nice of her to show up today so she can go back to bed when we're through. So that being said, the cases I have set today for pleas are State of Texas versus Juan Calvillo, cause 657038, represented by Mr. Warren Wolf. Are you ready to proceed, Mr. Wolf?
Yes, Your Honor.
Thank you. And State of Texas versus Garner Newman, cause number 648887, represented by Mr. Gary Chirac. Mr. Chirac, are you ready to proceed?
Yes, sir.
And we have a motion to revoke community supervision. Actually, I think it's a motion to enter adjudication of guilt and revoke community supervision on Mr. Joseph House, cause 674272, represented by Mr. William Simmons. Mr. Simmons, are you ready to proceed?
Yes, Your Honor.
Thank you. Let's do the 2 pleas first. And I have cause 657038, State of Texas versus Juan A. Calvillo, represented by Mr. Warren Wolf, and cause 648887, State of Texas versus Garner R. Newman, represented by Mr. Gary Chirac. The first document I have on each of these cases are entitled Defendant's Consent to Plea by Video Conference that purport to have both the defendant and his attorney's signature on it. In fact, Mr. Calvillo, and cause 657038, is this your signature on this document, sir?
Unmute, Juan.
I'm sorry. Yes, sir.
Thank you, sir. And Mr. Wolf, as attorney for Mr. Calvillo, is this also your signature on this document?
It is.
Thank you. Next case I have is 648887, State of Texas versus Garner R. Newman. Mr. Newman, is this your signature on this document, sir?
Yeah.
Thank
Your
you.
Honor, we need to have Mr. Garner's video on.
Thank you, sir. Where's it? I got Mr. Simmons looking at us now. Are
There
Mr.
you go.
Simmons and Mr. Garner together?
Garner Newman is Mr. Chirac's plea.
So where's Mr. Garner Newman?
Right here.
Oh, there it is. Can you lower your camera just a little bit for us, sir, so we can see your cute little face? That's it. Thank you, sir. Okay. Once again, is this your signature on this document, Mr. Newman? Is your last name, is it Garner R. Newman or Newman R. Garner? I apologize.
My first name's Garner. My last name is Newman.
All right. So, Mr. Newman, is this your signature on this document, sir?
Yeah.
Thank you. And Mr. Chirac, as attorney for Mr. Newman, is this also your signature on this document?
Yes.
Thank you. The next document I have on both of these cases is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions that purports to have both your signatures on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Calvillo, and cause 657038, is this your signature on this document also, sir?
Yes, sir.
Thank you. And Mr. Newman, and cause 648887, is this your signature on this document, sir?
Yes.
Thank you. By signing these documents, are each of you telling me that you've had enough time to either read these documents or have them read to you in their entirety? If you had any questions about what was on these documents, those questions were answered to your satisfaction by your attorneys. So that in signing these documents, you're telling me that you agree with and understand everything on these documents. Is that correct, Mr. Calvillo?
Yes, sir.
Thank you, sir. Is that correct, Mr. Newman?
Yes.
Thank you, sir. As attorney for Mr. Calvillo, have you had enough time to go over this case with him? And in your opinion, is he mentally competent? Mr. Wolf?
Yes, Your Honor.
Same question for Mr. Chirac, as attorney for Mr. Newman.
Yes, sir.
Thank you. Mr. Calvillo, are you a United States citizen, sir?
Yes, sir.
Thank you. Same question for Mr. Newman.
Yes, sir.
Thank you, sir. As attorney for Mr. Calvillo, does the state fully comply with discovery for you? Mr. Wolf?
I am satisfied with that. Yes.
Same question for Mr. Chirac, as attorney for Mr. Newman.
Yes, sir.
Okay. And my understanding, Mr. Calvillo's case, is a DWI first, or is it starting out as something higher and we're reducing it?
No, it's a DWI first, Your Honor.
All right. So Mr. Calvillo, about 657-038 to the charge of driving while intoxicated. First offense, how do you plead, sir?
Guilty, sir.
My paperwork says no contest. It
No
doesn't matter.
contest. I'm sorry. I'm
All
sorry.
right.
No contest. I'm
Court
sorry.
accepts the plea of no contest to the offense of driving while intoxicated. First offense. Is there an agreement for Mr. Calvillo?
There is, Judge. It is a $500 fine plus court costs, 12 months deferred adjudication, a DWI education course, a victim impact panel, the CATSNP program, a Smart Start mobile device for 1/2 the term, a DOEP course, Judge, and 50 hours community service.
50 hours.
50, that is affirmative, Judge.
And Mr. Wolf, is that your understanding of the agreement?
It is.
Mr. Calvillo, in clause 657-038, the court accepts your plea of no contest to the offense of driving while intoxicated. First offense. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt. Place you on 1 year deferred adjudication probation. It says a $500 fine plus court costs, DWI education, DWI victim impact panel, DOEP course, Community Alliance for Traffic Safety New Intervention Program, and either a Smart Start mobile or Lifesaver mobile at 4 blows a day for half the term, which is 6 months, and 50 hours of community service. Anything further from the state or the defense of Mr. Calvillo?
Judge, may I give some instructions, please?
Sure, great.
Nothing further from the state, Judge.
Nothing further on my end, Judge.
All right, Mr. Calvillo and Mr. Newman, this will apply equally to both of you. The probation department will reach out to you within 72 hours. So if you don't hear from them by the time you wake up next Tuesday, you need to call this telephone number, 210-335-7446. Advise them that you are placed on probation and that you need an orientation date. It is your responsibility to make sure that you sign your conditions of probation. If you fail to do so, you're going to be right back here via an orange jumpsuit. Okay? Anybody have any questions on that? All right. Thank you, Judge.
All right, Mr. Newman, in clause 6488887, to the charge of reckless driving, how do you plead, sir?
No contest.
I have no contest. Would that be accurate?
Yes.
Thank you, sir. Is there an agreement for Mr. Newman?
Yes, Judge. $500 fine plus court costs, 12 months deferred adjudication, a driver's education course, and 40 hours community service, Judge.
Susan, what's the long course on the aggressive driving course of CATS? 12 hours?
I believe so. I don't have my, well, wait a second here. I do have my list.
Maybe it's 8 hours. I don't know which one it is.
There's a 6-hour driver safety course. Then there's an aggressive driving for 4 hours. And then there's an aggressive driving level 2 for 8 hours.
That's the one we want. All right, thanks.
Thank you, Judge.
And Mr. Track, is that your understanding of the agreement?
It is, Your Honor.
Mr. Newman, in clause 6488887, the court accepts your plea of no contest to the offense of reckless driving. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt, place you on 1 year deferred adjudication probation, assessing a $500 fine plus court costs, 40 hours community service, and the Community Alliance for Traffic Safety 8-hour aggressive driving course. Anything further from the state of the defense of Mr. Newman?
Nothing further, Judge.
Nothing further from the state, Judge. Thank you.
Good luck, Mr. Newman. Thank you, Mr. Chirac. Mr. Newman, slow down just a little bit. We'll stop meeting like this. Have a good day, sir.
All right.
Anything further from the state of the defense on Mr. Calvillo or Mr. Newman?
Nothing further on either, Judge.
Either side have any questions for Ms. Gross with regard to probation? If not, you're out of here. Thank you. Okay, now I've got a clause number 674-272, State of Texas versus Joseph Millhouse, represented by Mr. William Simmons. This is a motion to enter adjudication of guilt and revoke community supervision. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which is purportedly signed both by Mr. Millhouse and by Mr. Simmons. And Mr. Millhouse, is this your signature on this document, sir? And your microphone's turned off, sir.
Yes, Judge, it is, sir.
Thank you. And Mr. Simmons, as attorney for Mr. Millhouse, it's also your signature on this document.
Yes, Your Honor.
The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which should be marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. My document is marked as a plea bargain, which is incorrect. So that needs to be administratively changed, Susan.
That's a Pat thing.
And is this your signature on this document also, Mr. Millhouse?
Yes, Your Honor.
And is this also your signature on this document, Mr. Simmons?
Yes, Your Honor.
Clause number 674272 is a motion to enter adjudication of guilt and revoke community supervision. Mr. Simmons, my understanding is this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
No, Your Honor. We were going to plead not true to the missed blows. I don't know if the court wants to entertain what happened on it. I mean, it's a pretty simple, I think, explanation. This is that we were trying to get. There's some stuff we're still trying to get from the Smart Start Mobile. But the bottom line, Judge, is, and I just sent an email over to you and to the prosecutors. I sent it to the CD, to prosecutors, to the e-service email. So it should be there. And you'll see on that, Your Honor, that it shows he's had two devices. One of them wasn't working. So he immediately got another one. The one that he has now, where it's shown with the missed blows, the first picture I sent you where it says what function, it shows even today his next blow is scheduled for 5 p.m. But even though he's still been blowing in it at 12. And so those missed dates tend to align with those missed tests that are on the MTR, align with the new machine. In other words, the new machine isn't, I don't want to say it's not registering the blows, but I guess if it's not programmed, in other words, I believe he's supposed to be blowing 4 times.
Mr. Simmons, I apologize for interrupting. Let me stop you there. Here's where I'm getting at with this, whether it's contested or not. My understanding of the law is that you have basically two options. Number one is you can request what I call a fully contested motion to enter adjudication of guilt and revoke community supervision hearing. In that case, really, the only real difference between that one and the one I'm going to discuss in a moment is that the probation department normally tries to call the original probation officer for Mr. Millhouse to testify. Now, the other option is that you don't request a fully contested. You can still plead not true to whatever you want. And Ms. Gross is going to read off of her documentation that was prepared by that original officer and just report whatever it is she said at the time. And that just, obviously, I'm going to be the ultimate trier fact on all this stuff anyway. So if we want to do it the first way, we have to check and see if we can get the original officer. Or if you want to do it the second way, all we have to do is let Susan read it off of the report that she has. You can still plead not true to everything if you want to. You know, it's up to you.
Yes, Judge. Well, Judge, we like to, I respect how you do everything with this court, so I would yield to how the court would want to handle it. But out of an abundance of caution on this one, just to get those technicalities handled, we would want to do the fully contested. So you would have the testimony of his probation officer in terms of how proactive he was with these issues with this machine.
Okay, so what would the original officer know about this machine that anybody else wouldn't know? Do we know?
They would have the conversations that were had with Mr. Millhouse, to my understanding. They would also have the that email correspondence with them, to my understanding, and they would know to just be able to, again, that's why I said probably out of caution, they would know the story of what's going on here in terms of that window with those missed tests. Because on each of those days where there are the missed tests, mind you, there's 3 other tests that he took. It is between that noon and 2 o'clock window, which is but then he's testing the others. We think it has to do with that machine. And there was a lot of correspondence back and forth with.
All right. Well, let me stop you there real quick. Does Mr. Millhouse deny consuming alcoholic beverages on or about August 20th, 2022 and August 10th, 2022?
Your Honor, as it relates to those 2 specific issues, I would have to yield to Mr. Millhouse. My understanding is that we were going to go, that we were contesting it.
Well, if y'all want to go in a breakout room and chat, here's the ultimate issue. If he pleads true to any one of these, that's all you really have to do. If you want us to try and check and see if the original probation officer is there, that's fine. But if Mr. Millhouse truly consumed alcohol, I'm not going to revoke him no matter what we say or do. I'll tell you that up front. He hasn't done anything that's so aggravated that we're going to take away his freedom and put him in jail. Worst case scenario, I think we're looking at a scram device is what it boils down to. And you can talk to me about that and about the way the machine works. Normally, our standard operating procedure is when somebody violates and drinks alcohol on a DWI probation, first off, we all know they have a problem when they walk in the door. So it's not really surprising to anybody that they might have a drink somewhere during their probation period. And we deal with that all the time. So that being said, I do not consider this aggravated other than the fact he's having a problem with his machine, and a scram device will fix that. The downside of a scram device is it costs $350 a month, but it guarantees that the machine will work. And if he's not drinking alcohol, it'll show that. The way I would usually do it, if he's got a device that's working and he wants to stay on the Smart Start mobile device, or I guess he's got a Smart Start, or Lifesaver is the other one we use. But they normally start at 4 blows a day, every 6 hours. If they violate, I crank that up to 6 blows a day. And if they do 30 days on 6 blows a day with no high brax or alcohol and no misses, no skip blows, I put them back down to 4 again. In Mr. Millhouse's particular case, they allege that he skipped a whole bunch of blows. I think your side of the story is the machine was not functioning properly, and that accounts for all the skip blows. Would that be accurate?
Yes, Your Honor.
All right. If he's willing to blow in the machine, we'll crank him up to 6 and leave him on the same machine. If he'd rather switch to scram, which costs him money, but will guarantee we don't have any more problems with the machine, we can go that way. Either way, I'm not going to revoke him. So y'all want to go in a chat room and chat about that and see if you still want a fully contested MCR or whether one of those options will work?
Yes, Your Honor. The only other question I would have is, he would be blowing for the duration of his probation then?
Yeah,
He wouldn't be able to get it off.
Well, I'll even leave him on deferred for that matter. I have the option of taking away his deferred, but
Okay.
if he's going to step up and do what he's supposed to do, that's not a problem. If he violates again, then all bets are off, and he's going to have a bad life probably. But for right now, that's what your options are. But I'll leave him on deferred, no hard feelings.
Okay, Judge. If I could have 90 seconds.
Absolutely, take your time.
Room 2.
Appreciate you, Your Honor.
Mr.